be here today. So
So I wanted to take a brief minute to just jump in on a kind of law commission side issue. Introduce Anne. She's in the upper left-hand corner of my screen. She is our summer clerk, summer staff, and she graduated from U of O with an economics degree this past May, and will start as a 1L at University of Oregon for law school in the fall. And so far, she has been a fantastic addition to the commission, and we're so happy to have her. She's here doing some administrative stuff and also doing some support work for their different work groups. So this is Anne in the corner. If you see her face, that's who it is. So thank you, Anne, for being here today.
welcome. Nice to have you.
Yeah, nice to be here.
Amy, did you have any other announcements, or is that it?
I will flag that the appeals, sorry, someone just popped in. The appeals work group we've got, it's probably the small group is probably gonna be on Monday. I'm waiting to hear from one person. But it will probably be mid-afternoon, somewhere between 12 and 2 on Monday. And I hope to send that email out by the end of the day.
You're talking about the
Sorry, I did it again, didn't I? The scope of review group. I'm so sorry.
I know what you mean, but
yeah, I'm sorry.
Okay, well, let's go ahead and get started here. If you haven't already pulled up the documents from the email that Amy sent out on July 3rd, those are what we're going to be working from, and most of the provisions that we're looking at are copied, or the proposals are copied into our agenda for ease of reference. And we are going to start with looking at the proposal on service address. And so there's some proposed language in your agenda for what's currently section 10 in draft, in our working draft 3. And so I guess I'll just open it up for any comments on the violation or misdemeanor section, which is the first section. Does anyone have any concerns or proposals to change that language? Okay. So is anyone opposed to adopting that language for the service address in an action for violation or misdemeanor? Please raise your hand if you're opposed. Okay, looks like we're good on that one. The next section is in a civil action, and there's some proposed language, and then there's also a question below about whether the civil action language is really necessary or not. And I don't know if maybe, Jim, do you want to explain a little bit more what the question is there?
Yeah, I have pretty significant concerns about putting the Justice Court in the role of basically guaranteeing that it has the correct service address for both of the parties. There's no requirement in law that parties keep the Justice Court informed of their current address, so the court has no way of knowing at the end of the case whether the parties are still residing at the last address shown in the court file. Timely service of notice of appeal is jurisdictional in civil cases, and so if someone gets it wrong because of misinformation provided by the Justice Court, I think that would be a real travesty. In my work for the appellate courts, I handled motions for well over 30 years, including many motions to dismiss, including many for failure to timely serve in civil cases, and all kinds of things can go wrong. And when things go wrong, all of a sudden we see affidavits from people describing who did what. on occasion, the appellate courts confronted with the situation of conflicting evidence regarding how service happened would remand the matter to the circuit court to actually hold a hearing, call in witnesses, receive document, basically have a mini hearing, make a record regarding what happened with respect to service. What I would really not want to happen on appeal from a civil case in a justice court is to either have a justice court staff person or the judge of the justice court get called into be compelled to appear as a witness and testify as to what information they had, where they got it from, whether they verified it, and so on. So it just really concerns me that we would insert the justice court in the process of determining the adverse party's address. In a civil case, I think that should be left between the parties, and the court should just stay out of it.
So Jim, to clarify, is your proposal that it would say that something to the effect that the justice court could provide the address that's in the court file, and it's the responsibility of the parties to provide a change of address if they change their address that's registered in the court file?
I'm not sure that we need to say anything. I would just leave the system the way it currently is.
Heather?
Thank you. So I helped draft this provision, and I had two comments. First, just that you might recall that the proposal originated from a concern in the violation and misdemeanor context that because we were changing the notice requirements for the service requirements for defendants, that they would have to actually serve on a varying agencies, that we'd want to ensure that they knew who those agencies were, because members of the public can often be confused by that. And so we had just created a parallel provision for civil actions. And I don't know that we had the same concerns from leading us to do that. And so I'm unsure that whether we need the provision at all. That said, what you were saying, Krista, or the clarifying question to Jim regarding how we could, I think we could, if we wanted to keep it, I think we could phrase it in a way where we made it more clear that the court was just providing what's on file, and that it wouldn't be, it'd still be the party's responsibility. But I just wanted to clarify too that I don't know that there was a particular concern motivating us to have this provision. We were just being thorough.
Okay, so it sounds like you also wouldn't be opposed to just having no provision at all related to that in civil action.
That's right. I wouldn't necessarily oppose it, although I can see how having the court provide the information could increase or promote like more accessibility for parties. But I recognize it's not the current system.
Judge Cross?
Yeah, I do think it would be helpful to have the court provide that information. I do think that I certainly understand Jim's concern, and it's a very valid concern. I think we could change the language slightly to say the Justice Court shall, this is on Roman numeral 1, the Justice Court shall, in its judgment or another effective manner, notify the parties that they may request the most current name and contact information of the adverse parties provided to the court upon which service of the notice is required. Because the court can't obviously guarantee that it's still current as we sit there in that moment. And that's probably what we could do. I think that certainly indicates that all we can do is give the most current information that we have, and that is what would be appropriate to reflect in the language. But I do think what we can do to assist parties who are not well versed in these processes that we can do, we should, and that would be I think that would essentially indemnify the court from the concern that Jim has. I think it would in any event. We can do the same thing in Roman numeral 2 under that, we could put the same language, exactly the same language in there to reflect that. And that would, I believe, address the issue, but still help the potential appellate litigants. I shared with Jim in a separate thing that when in my court, when we conclude a small claims trial where there's a judgment against one of the parties, I always ask if the current address information that the court has is correct, so that it can be provided. I know that's not required, and I know that's not probably the practice of everybody, but that's what I do to try and at least at the moment in time that the trial has concluded, that we know the court has up-to-date information on the parties.
All right, well, are there any other comments? We kind of have two potential options. One is Judge Cross was saying to keep the proposed provision, but just say it would be the most current information that's been provided to the court, or one to just remove that entirely.
One concern I have about what Judge Cross just said is, I understand in his court, a practice is that if a litigant phones in and wants to provide an updated address, the court goes ahead and receives that information and makes a change in the court record without that information having been served on the adverse party. Although it's unlikely to happen, it's possible that the litigant inadvertently or otherwise provides an incorrect address, or the staff person writes it down wrong, or that in the course of providing the information to the party for purposes of appeal, the court misinforms the person, either transposes numbers or something like that. And as a result, the appellant relies on that information and fails to timely serve the adverse party. Once again, the Justice Court is embroiled in the process of providing information that has jurisdictional consequences. The reason it is less of a concern in violation and misdemeanor cases is because timely service on the adverse party is not jurisdictional and is something that can be fixed after the running of the 30 days. Whereas in civil cases, it's jurisdictional. If we're going to do that, I think we should couple it with a requirement that the parties keep the court and the adverse party informed of any change of address. If parties comply with that, then of course the party would already have had notice of the change of address, and so the court need not be involved in it. But if it's the wish of the work group that the court should serve as a resource center, at a minimum, we should do that. But I would continue to have concerns of getting the Justice Court involved in providing information that I think parties will rely on and could be jurisdictionally effective information, not through any ill will. It's just because that's the way people are. We tend to make mistakes.
Paul? Paul?
Oh,
Jim?
sorry. Well, I tend to agree with the last comment Jim made, which is, if we're going to do this, we should couple it with a requirement that the parties keep the court informed. Could we also have something that said, if a party relies on the address that's in the court records, that would be sufficient for jurisdictional purposes if they use that address. That would get to Jim's concern about human error. If for some reason it was taken down wrong and a party relied on that, I wouldn't want that party to be harmed because they relied on something that was the result of human error. I mean, and that would get around the jurisdictional problem, and then we could fix the service issues, the notice issues later, as long as the appellate court wasn't deprived of jurisdiction, the circuit court wasn't deprived of jurisdiction.
Judge Cross?
I think that both of those ideas are good, because I do think that there's a benefit for the court being a resource for potential appellants. So I think Jim's suggestion that if we do keep the language, that we put in there a requirement that the parties keep the justice court informed of their current address, contact information, and so on, through the judgment, that would be, I think that would be excellent. And I also think that that Paul's idea is also good, to put in there that something along the lines of that, as long as the party has served the address that was provided to the justice court, or the pleadings are provided by the adverse party, that will count as complying with the timelines for filing. I think that both those ideas I think are good and can easily be implemented into the section.
All right, I'm seeing some heads nodding. So how about we go ahead and take a little poll here. So there's two proposals that we would keep the proposed language about service in municipal court, or in civil action cases, and also add a requirement that there be that parties notify the court and serve other parties any change of address. And that also, as far as the jurisdiction, if a party relies on the address in the court's records, that's sufficient for jurisdictional purposes. Is there any opposition to that proposal?
Kristen, no opposition, but I just wanted to suggest that there's some room that we make, if we're requiring people to provide contact information, that if there's some need for safety issues for people not to provide particular information, that's something we can accommodate.
And there's probably some other statutes that language can be pulled from, I'm assuming. Jimmy?
Could you restate that last concern?
On the service issue, I just want to make sure that we're not saying that people have to provide, for example, a home address or something if you have a stalking case or something like that, where there are safety concerns.
But there would be a
Well,
service address regardless, right?
Yeah.
Yeah, I
Jimmy?
guess we'd have to work, this has been a problem in the circuit courts, and actually the judicial department sought legislation to try to address it. But I think basically what that legislation said is if a person who's the subject of a non-contact order serves notice of appeal, because it's required in order to initiate an appeal, that the person cannot be held to have violated the non-contact order. But that doesn't solve the problem that the person who is the subject of the non-contact order may not know the address of the person. So maybe the solution is to require the beneficiary of a non-contact order to provide an address where notice of appeal can be served, even if it's not, it could be relative's address, something that there's some way to get notice to the person.
I guess I'm wondering, are we getting down into the trial level statutes that may or may not already exist at this point? How is it done? How is it done in general with the petition?
My recollection is that the legislation only applies to appeals from circuit court to the Court of Appeals, although perhaps we could extend it to justice courts too.
Jimmy?
Sure. So I would count myself as tentatively opposed or in favor of Jim's first option of just deleting the additional language for civil cases. My concern is that there's not really a particular problem under current law that we're solving. In the criminal cases, we're making a change in the law and we're adding this to compensate for that change. In the civil cases, it's not clear that there's a specific problem we're solving. Under current law, I think circuit courts certainly can do, or justice courts certainly can, maybe as a best practice, help litigants out with this, but this would require it in all cases. As I think we've seen, that would create certain problems that don't exist under current law. We need to add more language to correct those problems or to address them. I wonder if this has gotten a little too unwieldy or complicated for something that might not need to be there in the first place.
That's what I'm wondering as well at this point. Other thoughts? Judge Cross?
Well, it's hard to say whether that is an existing problem or not. Under current law, but you know, the person only has 10 days to get everything done to file an appeal in a small claims case. And if they don't have, you know, an address to serve the adverse party, and in a 10-day period, that creates, you know, an extra stress and conundrum that maybe they can't accomplish, or they simply give up because they don't know how to do that. So I do think it's hard to say whether that's a problem or not. Number one. Number two, I think that what happens currently, if it doesn't happen very often. Once in a while, you have a small claims case, for example, that involve people who are ex-domestic partners, and yes, sometimes you might have one where there is a stalking protective order, or maybe or have been in the past that may not currently be in effect, but the victim of that is still legitimately fearful. Certainly, I will receive a motion from that party to not have their contact information revealed to the other party, and if those circumstances, if I make those findings, then we would withhold that. Now, what does that do for the appeal? Jim's point is certainly very well taken on that in terms of the notice issue. I think if that order already exists, then if there is a statute that currently exists with regard to the circuit court and appeals to there and what the process is, I think that we should probably mirror that. I think that would be a good suggestion. I'm not familiar with that statute off the top of my head, I must say. But that's what we see. Good suggestions. That's currently existing law, Jim. Is that correct?
Yes.
Okay. Then we seem to be mirroring that would simply be the way to go, or even just by reference in the section to say that in the circumstance where a party has had their information protected, the appellant shall follow the procedure in ORS, whatever that statute is.
Heather?
Yeah, I wonder whether this could be resolved a couple ways, like one, you know, maybe just referencing existing procedures, as was suggested, or it seems like this like mess that we're finding ourselves in, it's not because of the requirement that the court just provide whatever it has on file, because it'll have something on file, right? The issue is that we're requiring parties to keep the court updated about their information, and then we have to say, well, what that means and what exceptions might apply and all of that. Do we still need to have that requirement that parties keep the court updated if we're going to have the other piece now that just says this, you know, if a party relies on the information the court had, that it won't be a jurisdictional problem. So the court will have something on file, it provides it. If a party relies on it, it's not a jurisdictional issue. If the service was, if there was an issue, do we need to have anything more?
That seems like maybe that's a way to just limit it to the appellate concern, rather than digging too deep. What do others think?
Well, it doesn't really address Justice Duncan's concern, which is if at the trial court level, the information has been withheld from the adverse party because of safety concerns for the other party.
that if we would still reference existing
Okay.
law about that, would that address that?
It would, the only other thing the other point I would make with regard to requiring parties to keep the court advised their address is of course that in a circumstance where a default judgment is in play, you want to make sure that the trial notice was sent to the correct address. Now, again, it's incumbent upon the parties to keep the court advised of their address. I would just say in general in that regard, because if they don't appear, but then because they have moved and not informed the court of their address, that's on them. But I could see where that could come up as an issue in an appellate proceeding.
Okay, so I think I'm hearing a revised proposal to not add the requirement of serving on the court a change of address, because that's sort of a more of a general provision, and it's dealt with however it's dealt with at this point. But just addressing the appellate concern by saying that if a party relies on the address of the court, that that's sufficient for jurisdiction, that the court has, that's sufficient for jurisdictional purposes, and also referencing existing procedures regarding protection for abuse situations. Is that any further discussion on that?
I just want to clarify what we're talking about when we talk about current law. Are we talking about participants in the address confidentiality program specifically, or are we talking about anybody who is the petitioner in a protective order?
I thought we were talking if an individual had in the trial court had their information protected, so by order of in this case, a justice court, that's what it would apply to. Maybe I'm mistaken, but that's what I understood the topic of discussion to be. So there would be an existing trial court ruling that the information be protected.
In the case itself.
Correct. That was my understanding. Yeah, in the actual case that is the subject of the appeal. Now that may be based upon another case where there was a protective order or something granted, but there would be an order or a ruling in the justice court that would be applicable to the case at bar.
Okay. So if there has been a ruling within the case itself that the address is protected, then there would be the exception. But we're not talking about generally people who have protected information.
That's my understanding. Yes, so that'll be and for the folks that have a different understanding, speak now or forever hold your peace.
I mean, yeah, I think that makes sense. I mean, as I understand how the address confidentiality program works is someone can use that address as their address for all purposes. And so I would have assumed that if they were already in that program, that's the address that they would have used when filing or responding to the initial complaint. And so they wouldn't even need to get a separate order from the court saying, you don't use that address, because they've already taken care of it. But as Judge Cross said, if there's an order in a separate case protecting the address of the residence where the person actually lives, it would be incumbent on that person to go to the justice of the municipal court and say, hey, court, please, I've got this other order, don't release my address to the opposing party.
So I guess the proposal would really be to say something to the effect that unless the court has issued a protective order or something to that effect. Or to the extent that any information is protected by a protective order. I don't know.
In the justice court, we don't issue a protective order, but if there's for example, a protective order that is in existence would certainly be a sufficient basis to make a ruling in the justice court that that party's information not be released to the other side.
But it would be referencing the justice court's ruling on protected information.
That's my understanding. Yes, that's what I think would make sense.
Okay, anybody opposed to that or want further discussion on that? Linda,
So I am so sorry, but I just need to clarify what we're talking about because I'm hearing a lot about the justice court order, but my worry is if you protect something in justice court, how is that going to be communicated to the circuit court? When those documents are sent to a circuit court, we are entering them into our program. We're doing all that. So if there is an address in a document, we're not going to catch that unless your court is redacting those addresses or based on an order of the court for protection, we're redacting this address. I'm just a little concerned if I'm misunderstanding that we're talking about the appeal to circuit court and what the circuit court can release based on a justice or immunity court order. I can see issues with that if we're not perfectly clear on communication. Because my staff are not reading the documents. They're entering the headers, they're putting in the notice of appeal, but they're not reading documents to see if you all have entered a protective order or something like that unless you're on behalf of your order, your staff are then redacting any of that information in those documents. So I'm just wanting to clarify what we're talking about and what the circuit court role is.
so
Before I don't object.
yeah,
Sorry.
Thanks for asking that. It's good to be clear. I think we're only talking here about how a party needs to serve the opposing party in the appeal. So when filing the notice of appeal, how they need to serve and how they will know what the address is to serve
Okay.
On the opposing party. So if the information has been kept from the other party, then they will not presumably be putting that information in their service address. And that's all that we're trying to address right here.
Perfect. Thank you.
Sure.
Now, that certainly is correct, but then when the justice court transfers its file over to the circuit court, the circuit court will then have that address information that's in there. So perhaps we, I don't know, again, you're saying into maybe too much minutia, but perhaps in that rare instance, and believe me, we are talking about a fairly rare instance, that the justice court perhaps would have to highlight the fact that that there was an order withholding contact information for one of the parties, so that that would be obvious to the circuit court, who doesn't care enough to read what we write otherwise.
That's not true. But here's my concern, honestly. Yes, a highlighted is good so that we know, but our documents are public in an appeal. So my staff on your order are not going to start redacting your documents from the Justice or Muni Court. So if there's information in those documents that are being sent to a circuit court that are under some kind of seal or confidential or a safety issue, your end will have to do something with those in that document. My end is not going to mess with those documents, but those documents are public on our software. So someone can come into a public terminal and look at that case and see what's in those documents.
Well, I think it would be incumbent upon the party to also to file another motion in the circuit court to have that information withheld from the public, because the justice court can't give an order like that.
Right.
So they would, so we could highlight it to you and send it over to you, but then that party would need to also make that motion in the circuit court and live with whatever the circuit court decided.
So
I just don't want our end to make I just want to make sure our communication is clear so that we don't put someone at risk just because that case has moved to a circuit court.
So at this point, we've gotten into a subject that wasn't really thought through in advance, I think. So I'm wondering if we should table that for further thought and work in maybe, anybody who's interested in thinking about that, and go ahead with, the broad idea here that we we have, I think, approved as far as the service. The service provision, how people will know the address, and then this is maybe a more complicated issue that folks would like to think a little bit more about protecting victims of violence. Does that seem like a good plan at this point? Okay. Then let's move on to the next thing is filing and trial fees. And we've got some proposed language in the agenda. And Jessica, I see your hand.
Sorry, just a really quick question for drafting purposes. So at this point, the work draft will just say that if the party relies on any address provided by the court, that is sufficient for jurisdictional purposes. And we are not putting in a requirement that the parties keep the court informed at this time. Okay, thanks.
I'm not hearing any opposition to that at this point. Okay, thanks, everybody. Okay, so moving on to the filing and trial fees. So the first section of proposed language is for the filing fees on appeal. And it's number 1 in your under subsection 3 of your agenda. And anybody have any comments on that? Okay, I'm not sure if people are reading or if nobody has any comments. I guess at this point, hearing no comments, is there anybody that is opposed or feels like we need further discussion on section 1 there, the proposed language for section 10A?
Judge Britton put a question in the comment, and which was, I didn't see where it says to file which court.
Subsection 4 of both proposals for justice court and municipal court would say when the appellant files notice of appeal, the appellant also must tender payment of the circuit court filing fee or a motion to waive or defer the filing fee. So perhaps it could be more explicit, but the understanding is that it would be filed along with the notice of appeal, either in the justice court or in the municipal court.
So we did address that it would be filed in the justice court, as far as I understood from our last meeting.
Right. The whole point of these rules is we're telling the public where to do things, and that doesn't tell me which court to file it in. That was my concern.
And
it just says to file it, right?
And I guess I'm not clear, Jessica, maybe you can answer if that is addressed in a different subsection or if that needs to be in here, but regardless, I think we can just make sure that it goes where it needs to go. Justice Duncan?
I think it is in another subsection and maybe we can just cross-reference it. Like when they file the notice of appeal, right? So in subsection 4 here, of the proposed language, it says when the appellant files the notice of appeal, we can like say pursuant or as provided in whatever section, and then that will tell you what court, which right now is the local court, which is the local court under the bill, right? But I think that we could either do the cross-reference or like Judge Britton is saying, just to make it easy to read, or even if it's redundant, put the court in sub 4. Perhaps.
Heather?
This is related to a different aspect of the provisions. I wasn't sure whether we had concluded the discussion on whether, and it sounds like this retains the filing fee for violations, and I was wondering whether the group had reached a consensus on that. Finally.
Sure, we can talk about that. So I think that, my understanding is that there are some people that are wanting to retain the filing fees. And, so I think that we don't have enough time to try to come to a different consensus on sort of any filing fee. There is a proposal by Jim to reduce the amount of the filing fee, and we can address, what people think about that at this point. Would anyone like to comment on Jim's proposal to reduce the amount? I think there would certainly be a fiscal impact if we do that, and OJD has provided the list of how much has been received in the last few years from the filing fees. Judge Cross?
Yeah, and I think Jim's proposal, and I gotta remember because it was reading it, I think it was to eliminate the trial fee or the filing fee, Jim?
The proposal would
Filing fee.
eliminate the trial fee altogether and to reduce the filing fee in circuit court from the current $281 to $170.
But with that, at least in Washington County, that is the filing fee that they've charged on small claims for at least my entire tenure here, was the 170. Because I think that statute, I find the current statute, I thought to be pretty clear on that the 170 is what would apply in a matter of $10,000 or less. So at least in Washington County, that hasn't been an issue at all. On a violation, again, my position has always been that the circuit court is in a sense their time and effort in the case is taken care of by the filing fee and the trial fee, and therefore if the judgment is rendered against the defendant, again, that then it should be sent back to the justice court or the municipal court, either way, depending on where it came from. It should be sent back to them for the collection of the fine that was imposed. So I support keeping the filing fee and trial fee in place that the circuit courts impose, but then we make it clear that judgments get sent back to the justice court. That's what I recommend.
Okay, so at this point, let's I don't want to bounce around too much on various issues here. So at this
They're
point,
the relevant issues.
I'm sorry.
But those are the relevant issues.
So I think that we've got the question of reducing the filing fee and eliminating the trial fee. I think that when we had first addressed this, it sounded to me like a lot of people were in favor of eliminating the trial fees because the trial fees weren't really being used a lot anyway, or it's more redundant. Is that something that folks are interested in or not? Heather?
I have a comment, or yeah, I have a comment after that.
Okay, sorry, I know there's a lot of issues here, so let's try and I'm thinking of taking them one at a time. Maybe this isn't going to work, but so let's talk about trial fees at this point. How do you folks feel about eliminating the trial fees?
I'm against it.
So part of why I recommended it is because the feedback we've gotten from a number of circuit courts that in fact they do not charge the trial fee. Also, as my memo pointed out, the trial fee statute itself is applicable only to civil cases, and current law defines violations cases as criminal cases. So it may be that circuit courts are not assessing the trial fee on appeal in violation cases because they recognize that violation cases are criminal cases, and therefore the fee should not be assessed.
What about 21-285, Jim? That seems to say that this specifically applies it to violations.
I think the language is susceptible of saying that the fee is due to the extent that the statute authorizing trial fees applies. And if you read that statute, it only applies to civil cases, not criminal cases.
Except 21-285 specifically says, in an appeal to a circuit court from a justice court or municipal court, in an action for commission of a state violation or an action for violation of a city charter or ordinance, but not in an action for commission of a state crime, the filing fee and trial fees required by 21-135 and 21-225 are required of the appellant and respondent. I mean, it's very specific. Seems to me that it requires that trial fee be paid.
And one other factor is my experience, as limited as it is that the there are no jury trials, obviously, in violation cases, and that the hearings last 15-20 minutes, half hour, and the minimum trial fee is for a half of a day. And so maybe, does it make sense that we're assessing defendants a trial fee equal to 4 hours when they get a 20 or 30-minute hearing in a non-jury case?
So we only have a few minutes here, so I want to see at this point if we can just take a poll and see where we're at. How many people are interested in eliminating the trial fees? How many people are opposed to eliminating the trial fees? Okay, it looks like we have a sizable lack of consensus at this point. So my thought is, because of our limited time to get this bill going, and it looks like a lack of consensus on this issue, that we're probably not going to be able to make any changes in whether to eliminate trial fees. And if anyone wants to work on this on their own and try and gain consensus, you're more than welcome to do that. As far as the filing fee amount, I'd like to do the same thing at this point. Who is interested in reducing the filing fee amount as Jim Nass was proposing? Who's opposed to reducing the filing fee amount? Okay, again, it looks like a significant lack of consensus here. And so I would propose that anyone who feels like you can reach consensus somehow with a proposal, you're more than welcome to try to do that. But I don't think we're going to be able to do that in our large group setting here. So let's move on to the language that was proposed in section 3 as far as the payment of the filing fees on appeal. So my understanding was, when we talked about section 3, subsection 1, the proposed language for section 10A, I don't believe there were any concerns about that language. Is that accurate? Okay, sounds like we're good on that. So moving on to section 2, proposed language for section 43A, municipal courts. Any discussion on that language?
Krista, can you just state a brief summary of what that is? I have trouble looking at it and talking to you guys at the same time. It's my weakness and shortcomings, but I'd appreciate that.
Would it help if do you have it up on your screen? It's
nope.
I'm
pretty primitive. I'm lucky to be here at all. But if you could just give a brief statement of what it says. I've reviewed it, but I'm not very good at going back and forth. I just got this little laptop and I don't have high technology going here.
Essentially, it says the parties have to pay the filing fee required by ORS 21.125. It's subject to ORS 20.140. The circuit court may waive or defer payment as in the manner provided by ORS 21.680 to 21.698. And the either a motion to waive or payment must be submitted with the notice of appeal using the form adopted by Chief Justice order.
Okay, yeah, thanks for indulging me on that. That I didn't have any opposition to that.
Judge Cross.
I just think in both the two sections on the fees, the subsection 3 in both says, circuit court may waive or defer payment, which is, I think, correct. And then subsection 4, when the appellant files notice of appeal, the appellant also must tender payment of the circuit court filing fee or a motion to waive or defer the filing fee. And I just think we should make it clear that motion is, they're simply filing a motion with that, and the motion will be ruled on by the circuit court. I think that's what I think that was our consensus last we dealt with this. If I'm wrong, let me know. I just want, for clarity,
submitted, it would be, this is how it would be submitted, and then yes, the circuit court would rule on the motion.
yeah, we would just send it over.
Everything's
with
transferred, yeah.
Yep,
So another
we send it over
provision
there,
about transferring.
and they rule on that motion. Yeah, that was my thought. Am I wrong?
No, that's addressed in a different provision, yeah.
Yeah, I just think that subsection 4 might want to clarify that for the parties, that could just say to tender payment of the fee or a motion to waive or defer the filing fee to be ruled upon by the circuit court. Yes.
How about if we let Jessica take a look at that and make a proposal in her next draft and see how it looks? Any other concerns with that?
Yeah, I have a concern about requiring use of a form. I have no problem with the courts providing forms for people to use, but requiring people to use a particular form. I know in some instances, lawyers have their own forms that they cobble together, that they devise and that they file for their clients. So I'm troubled about requiring, and what I don't want to see is a circuit court denying a motion to waive or defer that has all of the information that the court needs to rule on the motion, but may not be on the form provided by the state court administrator's office.
Lindsay?
I wonder if we could just reference the fee waiver and deferral statutes, because that's the statutory scheme that litigants need to follow, just the same with any other fee waiver or deferral in circuit court. And all of that will be imported if we just reference those statutes.
Any objections to that?
I mean, subsection 3 already does that. It says the circuit court may waive or defer payment of the filing fee required by subsection 1 of the section for the reason and in a manner provided in ORS 21.680 to 21.698. Do you think the reference needs to be clearer than that, or in some other subsection?
Well, maybe those subsections could be combined if we want to use one reference to those statutes, because that's subsection 3 talks about the circuit courts waiver deferral, and subsection 4 talks about including the fee or a motion. So they could either be one section that's all about the fee, and then we could reference the statutes once, or I think maybe it does need to be repeated because we're talking specifically about the motion.
Okay.
Judge Cross.
Yeah. 21.685. Does say the form of the application must be consistent with the standards prescribed by the Chief Justice under ORS 21.682 sub 4. And then give some specific things that have to be included, which I think covers the issue, doesn't it?
I think that's what Lindsay was proposing.
I think so. Makes sense.
Okay, do we need any more discussion on this, or are we, let's see. See hands kind of raising and lowering. Speak out if you'd like to discuss any of this further. So it seems like the proposal is to reference, I guess, either combine sections 3 or 4 or repeat the reference to ORS 21.680 to 21.696 in subsection 4. Justice Duncan?
Yeah, I think we can include a reference to the statutes in sub 4. That makes sense, and then I think the other things we can do that have been suggested would include making it clear that it's the circuit court that's ruling on that motion. And then to Jim's point, we can, and I think echoed by Judge Cross, we can say that they have to use the form or provide some, and Jessica can come up with the information, or provide some, in a form that substantially complies with whatever the created form is.
And that's, the last part is already in the cross-reference statutes, right? Okay. Okay, anybody opposed to that proposal? Okay, terrific. I think then that we've gotten through the major questions here that we were planning to get through. We do have a few outstanding questions after other feedback that we've gotten, and after this meeting we'll try to compile all of the remaining outstanding questions. We do have one major proposal from Jim Ness to eliminate the distinction between what's appealable from municipal courts and justice courts. I think we have 2 minutes right now. I would like to just take a real quick poll. Who is interested in eliminating that distinction as Jim Ness proposed?
Can I just say, I really feel like this was a very substantive proposal, and I don't have a position on it. And I know for me, like, I don't feel like I could weigh in on it at this time. I would strongly encourage just like having a little more time to consider before a poll.
That is a very fair proposal. So I guess we can readdress it at the next meeting, but my thought is that well, actually, what I might ask for is email feedback, I think, because it is a big proposal, and it would be nice to know if it's something that there's interest in or opposition to, and whether we can really spend any time on it, because I think if we're not close to consensus, we really don't have time to address it. So I guess if for those of you who have had a chance to think about it, if you could just let us know, that would be great. Or we can maybe just do a really quick poll on it the next time. But I think if there's not substantial consensus on it, we just are out of time for a major proposal. So at the next meeting, we really would like to resolve any outstanding questions, because the timeline here that we have is that Jessica would like to get us the draft of the working draft 4 with everything hopefully in there to the extent possible, and not having big gaps by the beginning of August when she leaves for vacation. And so we can have a chance to review it before the August 14 meeting and start to see what hopefully small revisions at that point are needed. Hopefully we've addressed the major things by that point. And obviously we do have some small groups still working on some major issues. And so ideally that would be resolved by the next meeting. If it's not, I understand there may need to be extra time, but I know everybody's working hard to resolve those issues. And I think, again, thank everyone for all of the effort that's going on behind the scenes here to do that. is.
Number one, I think we better have a motion to cancel that vacation of Jessica's. Because
Uh,
obviously, there's more important things at play.
Well, I think she's planning on doing her part before that vacation so that we all can have the next draft to review when she's gone. So that's wonderful. And it will be dependent though on how much of everyone else's work can be finalized before that point. So let's just keep working on this. Any other questions about how we're doing this, what we're doing at this point? Okay, well, I will not be here at the next meeting, but it will be happening and we will reconvene on, which day is it, the 26th, I believe? All right, 26th. Whatever your calendar says. All right, take care, everybody.